All right, folks. Jason Steele, broker here, your Gray Bruce and Simcoe real estate professional. Coming to you today to bring you the RECO Information Guide. It's a guide that we must give to you, the consumer, prior to engaging in any type of real estate. So I want to go over it very quickly because we are to have you read it. What you do with it is up to you, but our function, our job is to make sure that you've received a copy and have an understanding of what's going on. So it all started with new legislation. The Real Estate Business and Brokers Act is no longer. It's been replaced with TRESA, Trust in Real Estate Act. And it's got some new rules, pretty much similar to how things were supposed to be done in the past. And unfortunately, in a lot of cases, they were not done. So that is why we have the new legislation. So this is the RECO Information Guide. I'll be sending it to you by PDF to have you sign it. And it goes like this. So the second page is about this guide. You've received it from a real estate agent because you're considering receiving services from a realtor, or the agent is representing a client in a transaction where you might receive assistance. So in this guide, brokerage means the real estate brokerage. The real estate agent and agent mean the real estate salesperson or broker like myself. You and client mean the buyer or seller. Buyer and seller also mean the lessee and or lessor, respectively. So I do ask that you do read the guide. At the very minimal, listen to this entire video so that you understand. So page 2 discusses working with a real estate agent. Page 4, knowing the risk of representing yourself. So that is going to be called an SRP, self-represented party. Signing a contract with a real estate brokerage is on page 6. Understanding multiple representation is page 9. And if you have a complaint against a realtor or a brokerage, how to make that complaint. Now, of course, RECO does put in their legal disclaimer that you should seek legal counsel if you need answers to any legal questions. The guide is just intended to help you make an informed decision. So working with a realtor, agents in Ontario must be registered, which requires completing all the necessary education, carrying consumer deposit insurance, and professional liability insurance. Agents provide valuable information, advice, and guidance to buyers and sellers as they navigate the complexities of real estate transactions. Now, if you're a seller, an agent can advise you on market conditions. They can market or advertise your home, including arranging photographs, videos, and virtual tours. Provide referrals to other professionals you'll need, lawyers, home staging companies, home inspectors, things like that. They arrange and should be attending home inspections and any other third-party inspections. There goes my phone again. I'm going to stop that. My apologies. They can advise you on how to handle competing offers, sharing the content of competing offers and other aspects of the transaction. We vet the offers and we negotiate through all the paperwork, including price and terms, and we guide you through a transaction successfully. If you're a buyer, an agent can assist you with getting pre-approvals, can make you aware of any tax exemptions, gather and share information on neighborhoods, provide you with current market evaluations on the property, discuss if it's buyer's market, seller's market, the type of market you're in, how best to approach competing offers, and so on. You will also benefit, this is page 3, from the duties the brokerage and the agent owe you as a client. So as a client, undivided loyalty, folks. They must disclose everything they know and be able to get information. And if they can't, they also must disclose that. Confidentiality, you are owed the highest bit of confidentiality um, to anyone outside of the brokerage. Now, that would be except for where required by law. And there's a few things, if you're doing anything that's illegal, stuff like that. We must avoid conflicts of interest. So they must avoid any situation that would affect their duty to act in your best interest. If a conflict arises, they must disclose it. So, for example, if I'm selling my own home, that's a conflict of interest, but that's okay as long as I disclose it. I would still have to provide you all the information that I know about the house. Now, you as a client have responsibilities as well. You must be clear about what you want and don't want, and make sure you share all the information that might be relevant. For example, if you're going through a divorce, share the information, especially if you're paying alimony, child support, if you have your home has been the site of a violent crime, anything like that that could affect the sale. You need to respond to your agent's questions quickly, understand the terms of your agreement, and pay the fees that you have agreed to. And that'll be on page 7. You need to know the risks of representing yourself. Again, this is called an SRP, a self-represented party. This means that you've chosen to represent yourself, which has different rights and responsibilities. And thankfully, very few buyers or sellers will make this choice because it could end up in a nightmare. There are significant risks to representing yourself if you don't have knowledge and expertise required to navigate the transaction. You'll be dealing with a seller or a buyer who is benefiting from the services, opinions, and advice of a experienced real estate agent in most cases. RECO also recommends that you seek independent professional advice before you proceed as a self-represented party. Now, I do believe lawyers are going to probably jump on this in a hurry, thinking that they can represent you and know everything they need to know about the property, which is probably not the case because you're not going to get a lawyer to jump out of his desk, come out of his office, and go survey the neighborhood. He's not going to talk to neighbors. He may not know that the neighborhood was involved in methamphetamine distribution and or manufacturing. This is why you need a local realtor. If you choose not to work with a real estate agent, it's your responsibility to look after your own best interests. This could be including things like inquiries about zoning, determining the value, determining how much you're willing to offer or accept, navigating competing offer situations, and deciding what terms you want to include in any offer, and preparing all the documents. The real estate agent is working for another party in this transaction. So if you are an SRP, they are not representing you, folks. They have to be honest with some things, but they definitely do not have to discuss anything with you as a self-represented party. The agent has the duty to do what's best for their seller client. Or if they have a buyer client and you're selling your house as an SRP, that's the same thing. The agent is obligated to share anything you tell them with their client, which might not be in your best interest, including your motivation, the minimum or maximum price you're willing to offer, accept, your preferred terms or conditions for the agreement of purchase and sale. The agent cannot, while you are an SRP, a self-represented party, the agent cannot provide you with any services, opinions, or advice. That means no, you're not getting the area pricing, you are not getting any opinions, and you are not getting me to draft your offer. I'm sorry. The agent cannot do anything that will encourage you to rely on their knowledge, judgment, or skill, and encourage you to represent yourself or discourage you from working with another real estate agent. Any assistance the agent offers you is a service to their own client, not you, is in the best interest of their own client, not you, is to help their client buy or sell a property. The agent must give you RECO's information disclosure in a self-represented party form and walk you through it before they can provide you assistance. You will be asked to confirm whether you've received it and understand what it means to be a self-represented party. Alexa, stop. You have the right to change your mind. If you're concerned about completing the transaction on your own or you need advice from a realtor, you can choose to become the client of a real estate brokerage at any point during the transaction. And that would be on page 6. And we are getting there, folks. So, signing a contract with a real estate brokerage. When you become a client, you sign a representation agreement. It's a contract between you and the brokerage. If you don't want to sign the agreement, you should not expect the real estate agent to provide you any services like showing homes. A realtor must sign a representation agreement to have you as their client. They can be called buyer representation agreements or seller representation or listing agreements. The agreement must be put into writing and presented to you as soon as possible. Now, protect yourself by reviewing the agreement in details. Now, I will have further videos up on all the different agreements and what they mean because there's some pretty important things in each agreement. Now, what to look for in a representation agreement is your representation agreement should describe the duties owed to you, the services you will receive, your rights and responsibilities, what you will pay, and specific terms of the agreement, including how long the agreement can last. Some of the things to look for is the name of your designated realtor representative. If the contract is designated representation agreement, the name of your designated rep will be included. So more than one real estate agent working at the brokerage can be identified as your designated representative. Now, the whole idea between designated representation, the agent represents you and must promote and protect your best interest. The brokerage and its other agents will be required to treat you impartially and objectively. Sorry. An important aspect of designated representation, it reduces the likelihood of multiple representation. Now, in my opinion, multiple representation is not a bad thing, provided there's full disclosure on both sides of the transaction, knowing that a few things you cannot discuss, the price you may or will be willing to accept as a seller, the price a buyer is willing to go to, the motivations of both, basically the money and the motivation of both parties. Designated representation was introduced on December 1st, 2023. I'm not a fan of designated representation because to me, it's still similar to multiple rep in the fact that the transaction is still within the brokerage on both sides. Now, all parties are to remain impartial, but having said that, they are to remain impartial in multiple representation as well. If you're a buyer, you should consider the scope of the agreement carefully. Your agreement might identify a specific property, a geographic area you're searching in, a type of property you're looking for, or other specific requirements. Services must clearly be set out in any contract. There is no standard set of services. Brokerages offer a variety of service options, and you can choose. Payment amount and terms, you and your brokerage decide the amount that you will pay for services. The amount is not fixed or approved by RECO or any government authority. You get what you pay for in most cases, folks. You can agree to a fixed dollar amount, a percentage of the sale price, or a combination of both. And agreements must also identify circumstances in which these amounts agreed to might change and how they will change in each circumstance. For an example, if I'm representing you at, and I'm just throwing a number out there, at 5%, and we end up in multiple representation, I can choose and agree with you to reduce that compensation down to, say, 4%. I will remove 1% or 2%. Again, that is up to you and your broker representative. If you're a seller, your agreement needs to clearly indicate the amount you agree to pay, the amount you agree to pay and compensate the buyer brokerage, and the amounts you agree to pay might change if you consent to multiple rep, like I just discussed. If you're a buyer, your agreement also needs to clearly indicate the amount you agree to pay to your brokerage. How the amount you agree to pay will change if the seller agrees to cover some or all of your fees, and how the amount you agree to pay might change if you consent to multiple representation. A seller might not offer any amount to cover fees you owe to your brokerage under your agreement. This is more or less a mere listing. This is where a seller is selling themselves, and this could affect the amount you are able to offer for a property depending on your financial circumstances. Termination provisions. The agreement should list all circumstances when the agreement can be terminated. Review when the brokerage can terminate the agreement and make sure you're aware of any penalties or costs. Two important circumstances to be aware of: multiple rep. You do not have to agree to multiple rep, and your agreement should be clear about what happens in that situation. And number two, changing your designated representative. If you've entered a designated representation agreement, the brokerage cannot appoint a different designated rep unless you agree. Expiry date. The expiry date must appear prominently on the first page. There's no set time or standard. If it's over 6 months, it must be signed. But keep in mind that holdover clause could mean you owe money even after the expiry. This one is very important because most agents do not explain when they're signing a second listing. And what I mean by that is, if a listing is expired with one brokerage and they call in another brokerage, this is where the holdover clause is very important. It's designed to protect the brokerage, and there's no minimum or set time for a holdover period. For example, if you're a seller and your agreement includes a 30-day holdover, this means that even if your agreement has expired, you might be obligated to pay the brokerage a commission if you sell your home during that 30-day period. And the same goes with a buyer. Now, if you've signed a new agreement, this is important, folks, a new agreement with another brokerage during the holdover period, and you've signed it at less commission, you will owe the first brokerage the difference in the commission should the property sell during that holdover period to someone that was introduced by any means to that property during the listing period. For example, Joe Buyer comes to my open house. He loves the home. A day later, his agent reaches out and says, "My client's very interested. Please keep me in touch." A week later, the house expires and they list with somebody else for a percentage less. Joe Buyer and his agent write an offer and the offer gets accepted. You now owe the first brokerage 1% of the sale price in that holdover if they pursue it. So please keep the holdover in mind. Not many agents discuss it because every time I talk to a homeowner after signing the second listing agreement, they tell me, "Oh, I didn't know that." So now you do. Multiple representation means a designated rep or brokerage rep represents more than one client with competing interests in the same transaction. This could be two buyers. This could be, sorry, this could be I'm representing two buyers on another property, or I'm representing one or more buyers on my listing. That is multiple representation. Okay. So brokerage rep, multiple representation exists when the brokerage represents both the buyer and the seller in the same transaction, or two or more competing offers interested in the same property, even when the clients are working with different real estate agents. Multiple representation in designated representation exists when the same real estate agent is the designated representative for both the buyer and the seller in the same transaction, or for two or more competing buyers interested in the same property. It's not permitted unless each of the clients involved agrees. The brokerage or your designated rep has a duty to promote and protect your best interest and avoid conflict of interest. If your brokerage or designated rep enters into agreement with another client who has an interest in the same property, this places both clients in multiple rep. Multiple rep introduces risks you and your other client should consider. It's important to understand the risks. If you agree to multiple representation, the brokerage or designated rep must treat each of the clients involved in an objective and impartial manner, cannot maintain undivided loyalty to you or promote and protect your interests over the interests of the other client, and cannot offer advice to you about such things as price you should offer or accept, or terms that should be included in an agreement of purchase and sale. What to do before you agree to multiple rep? The brokerage is required to provide you with a written disclosure, how the brokerage's duties or the designated rep duties will change, the difference in services you will receive, and change how much you pay the brokerage. Until this information is disclosed to all clients in the transaction and they agree in writing, the brokerage or designated rep cannot take any further steps on behalf of their client. You can refuse multiple information or multiple representation. If you don't agree, the brokerage or your designated rep is not allowed to proceed. Agreeing to multiple representation significantly reduces what the brokerage and its agents can do for you, which could have consequences and costs. A note about content and other offers. You may have seen articles in the media about open bidding or open offer process. Buyers in Ontario who have made an offer on a property are entitled to know the number of competing offers. Sellers choose how much other information, if any, they want to share about the offers they receive. If you are a seller, you decide how much information you want to share about competing offers. Your agent will advise you based on the characteristics of your property, market conditions, the content of offers you receive, and other things. You need to provide a clear written direction to your agent before the content of any offers can be shared. Personal or identifying information in offers cannot be shared. If you are a buyer, you decide whether you want to participate in a process where the content of your offer might be shared. Your agent can tell you the steps to take to avoid having the content of your offer shared. Be aware that the seller can make the decision to share content at any time you may not know in advance. My take on that, I am a big proponent of open offers. I think transparency in the marketplace only can help, especially during a down market. What do I mean? Well, if you're a seller and you're in a multiple offer situation because you've priced the property properly, you want to share these offers to try and get maybe a little bit more money. And the whole idea there is if you're a buyer, I've had many buyers in the last little while after the last couple of years of craziness say to me, I'm not getting into a bidding war. It's going to have too much money on the table, and they walk away. Well, for a seller, it's not good to have them walk away. But as a buyer, how do you know what you're walking away from unless you see it? So gone are the days right now where people are paying 100,000 over. Multiple offers are normally in and around a couple $1,000s, and that's leaving money on the table. So if you have, as a buyer, let's say you have an extra $5,000 in your budget, and you decide to walk away, and you find out that that house sold for $2,000 under where your budget was, are you going to be upset or not? So that's how, to me, open offers is going to help the marketplace and keep buyers in the lack of a better words, in the game. How to make a complaint. So if you are aware of any misconduct by your brokerage or your representative, first, you should contact your brokerage and hope that they can mitigate and resolve the complaint. Hopefully, it wasn't anything too bad. If not, you can file a complaint with RECO. All the information is here, and complaints such as acts on becoming a realtor, um, your realtor is not doing their job properly. If you're a buyer, you've gone through a home, and for example, they've stated that the bedroom in the basement is, in fact, a bedroom, but it contains no window. Well, then we know it's not a bedroom and they're misrepresenting the listing. That is complaint worthy. That is how to make a complaint. Now, at the back of the page is the acknowledgement. It's where you see the realtor's name, the brokerage name, the date the info was provided to you, and a place for you to sign and date. It is imperative that you sign this on behalf of yourself, whether you're an SRP or a buyer client, because RECO needs to know that you know and acknowledge having read this information guide. So I want to thank you. I know this was long and drawn out, but it is very important. It is new under the Trust and Real Estate Act legislation. I want to thank everybody for joining me today. Please have an amazing day, and we'll talk to you soon.